This episode of AHLA's Speaking of Health Law is brought to you by AHLA members and donors like you. For more information, visit AmericanHealthLaw.org.
Hello, everybody. Welcome to our continuing series of AHLA Corporate Governance podcasts. This is Rob Gerberry. I'm the Chief Legal Officer of Summa Health and the President-elect Designate of the AHLA. Today's episode relates to a fundamental element of corporate governance and one on which we continue to receive questions on its best application: minute taking at board and committee meetings. The General Counsel has typically been called upon to interact with minute takers in at least three ways: as scrivener, actually taking the notes and preparing the minutes; as reviewer, reviewing and commenting on the draft minutes as prepared by another; and as an advisor, working with employees designated to take minutes to establish guidelines for their preparation and application. This connection has been expanded to now evaluate and advise on the use of AI technology in the work of the board, including but not limited to the use of AI in minute-taking efforts. This renewed focus comes at a time when minutes are the subject of an increasing level of interest with respect to such matters as internal and external investigations, litigations, and books and records requests. All of this places a premium on the proper preparation of minutes and on the General Counsel's participation in this minute-taking process. And to help us discuss this issue today, as always, we're joined by my AHLA colleague and friend, Michael Peregrine, who's both an AHLA fellow and a fellow of the American College of Governance Counsel. So welcome to 2026, Michael.
Rob, Rob, what do you think if people knew that we thought a big deal was spending a half hour discussing board minutes? I think there would be a resulting drop in law school admission as a result. But you and I love it, and I think you're right. I think a lot of our members really do get into minutes, which is a fun thing.
To your comment, Michael, they truly may let AI take over the world if they realize they were spending these 30 minutes. So let's skip right to the first question about best practice: long minutes or short minutes?
Yes. Actually, and my point is that there's really no best practice here when it comes to the length of meeting minutes. But I think, Rob, we can take some direction from Leo Strine, the former Chief Justice of the Delaware Supreme Court, who's written some wonderful pieces on this subject. Justice Strine has emphasized the importance of establishing a thoughtful approach to the preparation of minutes. In other words, let's focus on a standard approach in implementing it, as he said, professionally and consistently. And I want to emphasize the concept of consistently. As to your question about long or short, I think the best answer is pick a lane, stick with it. And it's, kind of less the style. If we don't pick it and be consistent, we're really monkeying with the minutes, and we're raising the question of, well, what is the way the organization approaches minute taking? We're creating the potential for, minute taking to be the subject of some skepticism. So consistency, whether they are long or short, really is the answer, and that's the best way to support minutes.
So no stance by Michael Peregrine on the long or the short of it?
Yeah, for a price.
So doesn't that circle back to our core purpose of meeting minutes?
I think it's also important to point out that Justice Strine isn't saying I've got a preference for short form or long form, but he recommends, and this is another point with respect to consistency, Rob, he recommends against deviating on individual situations, except in certain situations where, for example, and you've certainly been through this a lot in your position, if we've got a big meeting coming up, if we've got, for example, the subject of an internal transaction or a special transaction that's being considered by the board or committee, then it may be very valuable to have long form minutes. He notes that the more minutes resemble an attempt to create a transcript, and I know this is a subject that a lot of people ask, the more they do that, the less opportunity for meeting participants to credibly testify, and this is kind of the worst case scenario, credibly testify at a later date as to the meeting events that weren't chronicled in the minutes. So I think that we're talking about two things, generally speaking, being consistent and being willing to deviate, but only in situations where the subject of the meeting is important. the key point is that all parties are clear as to what method is being used as a corporate practice and why. And what jumps out to me, and we'll talk about this a little bit more today, is not only the option to deviate in circumstances, but also the emphasis on the responsibility of meeting participants and their familiarity with meeting events. And I want to keep coming back and emphasizing it. We're going to talk a lot in our podcast today about the style of minutes. We need to also emphasize the importance of the board members or committee members' familiarity with the events. So to answer your question, does it circle back to the whole purpose of meeting minutes? Sure, it does. And I'd be interested in your view on this, because I've always understood that there were probably 3 or 4 purposes for corporate minutes. Number one, and I think you see this in most corporate treatises, the real goal is to preserve an accurate and official record of governance proceedings. I think Delaware law establishes basic expectations that minutes covering big issues, like compliance risk evaluation or evaluation of M&A or internal investigation or something like this, will present this is important, the material factors on which the board considered in its deliberative process. That, if I'm a scrivener, if I'm a minute taker, that's the real question. Have we reflected in the minutes the factors which the board considered in whatever the subject matter was? Again, going back to Justice Strine, he pointed to, in his most recent article, to a recent Delaware decision that noted that minutes are not transcripts. They do not need to be. In other words, I think the point is the scrivener can accomplish the goals of identifying the factors the board considered in its deliberative process without going to the use of a transcript. More on that later, and more on your AI question later. I think the justice interpreted the case law as emphasizing the need for minutes to, number one, summarize again the factors that the board considered in its decision making. Number two, document the material. This is another important thing, Rob, I think. Document the materials received in connection with the meeting. And number three, summarizing the advice of the advisors gave. So factors considered, materials received, advice given. And to me, I'd add one more purpose, which is, and I think it's actually one we kind of forget about, good meeting minutes, I think, should remind board members or committee members of what they have accomplished in the meeting and what risks and tasks remain to be addressed in the next meeting. And I think that becomes important as we have longer gaps between board meetings. So long way of saying meeting minutes, just in my mind, serve an incredible positive purpose and are really worth continuing education with the board and the committees.
As a reviewer of minutes, I'm glad Justice Strine held the way he did. I view them less as a transcript and more of how can we best evaluate how the board came to a decision as we reflect back.
I think that's right. And one of the things, Rob, that I like to focus on, and I'm very interested in your perspective as a general counsel, is, how can we, from a CEO's perspective, I've always seen CEOs not being super fans of minutes, that, purposely and understandably trying to say, gee, let's help the board keep this meeting as lean and mean as possible. Let's not waste their time. Let's remove the kinds of things that were that are a drag on their time and effort. So it becomes incumbent, I think, on counsel, general counsel, and outside counsel to help encourage both the chair and the CEO to invest more time in the meeting, in minute taking, and preparing process. And my arguments would be, number one, I mean, I think it's all, it really actually is kind of a compliance argument about saving money. Number one, I think the court's decisions have made clear that well-prepared minutes will be viewed really favorably when they're thorough, contemporaneous, and consistent. So this couple of C words again. This matters, I think, especially, Rob, when you're trying to use minutes as evidence or in a persuasive manner, and using director testimony that's consistent with the minutes. I would also point out, and we'll talk about this more in a second, that these kinds of thorough and contemporaneous consistent minutes also help satisfy legitimate books and records requests And if you've ever been through one of those, they're a real pain in the tail. And again, this is another way where well-prepared minutes will help respond to those. I think on the flip side, minutes are unlikely to carry much weight when they're short. They're so short that they fail to cover key topics, have been approved long after the meeting actually occurred. Don't make a reference to advisor presentations. Otherwise, don't give whatever the reviewing party is, whether it's a court, whether it's a litigation investigative body, whatever. It doesn't give the third party confidence that the minutes actually speak to the relevant factors that motivated a board's action. Confidence, I think that's really important. We want to make minutes such that they can be used offensively or defensively in a way that we think that people will look at them and say, this is useful. This is an accurate representation of what went on. I also want to point out, and those of you who work in the executive compensation area will recognize this, or in the tax area, that minutes can be used to reflect the kinds of practices that are intended to satisfy certain statutory requirements or regulatory safe harbors. In the corporate governance world, that could be state laws. Rob, you and I've worked with in the past on how to essentially rectify a board decision that was made with a conflict of interest involved. In the tax exempt world, I think it's proving out the requirements for the rebuttable presumption of reasonableness in compensation decisions. You can demonstrate without, breaking your arm by patting yourself on the back. You can demonstrate that the committee or the board went through the steps that were necessary to satisfy whatever safe harbor that you're shooting on. And we could really go on and on from here. There's such a huge defensive value to well-prepared minutes that I just can't figure out why more CEOs and board chairs don't place a greater emphasis on them. Investing, and again, and this is just the lawyer talking, the corporate governance lawyer, but investing time and energy in the minute taking and review and approval process, I think can save tons of money down the road. And I'll bet you that our litigators and our white collar colleagues that may be listening on this would agree.
So, Michael, what I'm hearing from you is you may not like, or I may have to step some time with the committee and a board I'm involved in, when every time we say, does anybody have any comments on the minutes? And he said, I love the font. And he says that every single meeting.
Yeah, that's right. There you go. He's paying attention.
So, Michael, is there any urgency to the timing of preparation of board minutes? It can be a painstaking process, and there's often lots of time between board and committee meetings. Is there a certain rush that we should put to this process?
Yeah, I think so. And this is another thing that kind of gets lost in translation a lot. It's a pain in the tail to take minutes, and it's a pain in the tail to review them. But I would say that there's plenty of urgency associated with it. Number one, as I said before, and pointing out the Chief Justice's comments, the speed with which minutes are prepared and submitted for review and approval can make a big difference in how the reasonableness of board decision-making on major issues is perceived by folks. The failure of key parties, again, the Justice notes, the failure of the key parties, whether it's the board, the management team, or council, to document and review the whole discourse of the prior meeting. I love this phrase, impoverishes the deliberative process itself, not just the record. And I want to say that again. It's just essentially saying if you don't get this done on a timely basis, it carries the risk of impoverishing the deliberative process itself, not just the record. I love that phrase, and you can guarantee I'm going to find a way to stick it in something I write in the future. Of course, I will attribute it to the justice, but nevertheless, the point is made. You're just shooting yourself in the foot if you take a long time. And of course, memories are dim. So I think there is urgency. Get them done fast while people's memories are fresh. I would hate to be in a situation where you're relying as a defensive mechanism on corporate minutes that were prepared 3 months after the board meeting occurred.
Michael, I love that phrase as well. So
I'm using it. You can't use it. There's only one lawyer per phrase.
Justice Shrine didn't share it with all of us, huh?
No, just me.
So you mentioned the relationship of minutes to third-party books and records requests. Why is your belief that that's so important?
I think first and foremost, in my own personal practice, I've really seen over the last couple of years an increasing use of statutory rights under the not-for-profit laws as well as the business corporation laws of a board member or a former board member or someone else to make a company's books and records request. People who want to create real problems, people who do not wish the organization goodwill, people who want to be a real pain in the tail will, and their lawyers, I should underscore, will use books and record requests to, it's a kind of a rope-a-dope strategy. And you want to be able to get rid of those and respond to those quickly. And if you're in a manner of litigation, you want to be able to establish credibility of the board. So I think that thoughtful minuting practices can really help fend off challenges to the adequacy of the books and records that you're providing in response to a request. And I think it can discourage regulators too from pursuing their own enforcement actions with respect to major issues. And as I've said throughout this podcast, Rob, the ability to produce formal board level documents like minutes, resolutions, advisor presentations for key matters, and stuff like that, if you can produce them immediately upon the request, it makes the company look good. It makes it look thoughtful and responsible in the context of judicial proceedings, regulatory inquiries, or whatever. But I do think absolutely it's shocking to me how books and records requests are abused by plaintiffs' counsel.
So let's pivot, Michael, to us for a second to the approval process. Many boards, as part of their efforts to streamline their meetings, just put minutes in the consent agenda, and there it gets glossed over in many ways. What's your belief or thoughts on that process?
It wouldn't be my choice. I think it really undermines the importance of minutes generally and their advanced review by the board in particular. I'm not a huge fan of the consent agenda generally. Even it's a little bit better if it's by advanced written approval or something where somebody has to meaningfully put their name on something and said, yes, I consent to the approval of minutes. But it's just kind of, as you said, it's the tendency that we're going to gloss it over. So I think there's a real risk that improving it, including it in the consent agenda, demonstrates a lack of appreciation for the value of minutes. If you have to use it in certain circumstances, the board should be encouraged not to approve them just by rote. This is especially with respect to minutes that relate to, as I said before, significant matters, big deals, strategic decisions, litigation, risk, compliance, whatnot. And I think in a situation, if the chair and the CEO say, we're going to put this on the consent agenda, then I would want one or both of them to send out a note saying, look, we're going to do it this way, but please, 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 before the meeting, make sure that you have reviewed these minutes because and don't hesitate to raise a question. And frankly, I have seen there is a tendency, I think, amongst conscientious directors to actually raise more questions if the meeting minutes are being proposed in a consent agenda than if they're to be proposed for approval in a regular agenda. Making exceptions to allow for minutes approval as part of an oral or written agenda approval process can be a real slippery slope. Once you do it, it just becomes easier to do it again and again, and then it becomes standard practice. I think that the savings in time of using a consent agenda practice, if it even is allowed under state law, will be more than offset by the danger of that you create by casting some kind of skepticism over the quality of the minutes.
So, Michael, another common question in our space is retention periods. How long do we think corporate minutes should be kept?
Well, I have a firm answer on that, Rob. I have no idea. But I actually think, it's like when we were young associates in law firms and doing state-by-state surveys of document production statutes in the 50 states. But I do think the answer to that, not to be a smartass, I think the answer to that reflects a combination of the applicable state and federal statutes regarding document preservation and advice from white collar and litigation counsel as to the risks of deleting records when there's a general awareness of controversial subject matters. I do think I'm a big fan of consulting your white collar litigation counsel with respect to minutes practice. There's oftentimes, I should point out, there may be kind of a disagreement as to, from a corporate governance perspective, as we've said, we want to build into the minutes enough information that it makes it clear that the board went through a deliberative, thoughtful process. That may be anathema to white collar and litigation counsel who are saying we're giving too much up. We're saying too much. Both sides are right, but it's a question of really what the company values most from a risk profile perspective. I think it's an issue that has to be addressed by the general counsel, the CEO, and the board chair. But we need the advice of the white collar guys and the litigation guys.
So I've also heard some executives say, well, part of the value of having a lawyer is that my meeting minutes, if they're reviewed or taken by the lawyer, now become attorney-client privileged. What's your belief on that?
Everything's covered by the privilege, isn't it, Rob? Just by having you in the room, doesn't that sprinkle the blue fairy magic dust on we're privileged? I think most of our listeners today understand where we're coming from here. And I think this is your question goes to is just another reason why there's a real value in having privilege related training for members of the executive leadership team, and to do it before meeting, before we get into trouble rather than after. The answer obviously is no. Minutes are usually treated as part of the ordinary and normal business records. Are there portions of every meeting in which there's a need to protect the privilege of legal advice provided, by counsel who's attending the meeting? Yeah. My advice is always for the general counsel to solicit the input again from the white collar litigation guys who are going to be in the meeting to help establish a mechanism for within the conduct of the meeting as a whole, and thus the preparation of the minutes, to deal with privileged communications. They'll say stuff like, at the board's request, counsel was asked to advise the board regarding regulatory considerations or litigation matters. And then you just simply, in the minute taking process, you do a Rosemary Woods. You just don't say, you delete, you don't reference the substance of that advice in the minutes. But I'm sure in your many years of practice as general counsel, you have a process that you use internally to say, we're going to take a break now. We're going to bring in outside counsel. This is a conversation subject to the privilege, and you essentially mark that to the whoever's taking the minutes.
So in our industry right now that's so focused on financials and resources, we hear many CEOs and executives say, well, let's take advantage of AI. Let's see if AI can streamline the process. What's your take on AI recording board meetings and or generating board minutes from those recordings?
Well, the old fogey here, and as we've discussed on our podcast before, I'm not a huge fan of AI as a boardroom tool at this stage of the game. I'm not saying forever, but I'm a skeptic that it can provide the value that's promoted by so many fans of AI. I think there are too many questions, too many uncertainties, unclear as to the real benefit, and that's especially with respect to AI taking board minutes. Not just AI providing all the materials for the board and stuff like that. I think, again, to be fair, I understand the goal of using AI as an efficiency tool, but I don't think we're there, because AI is not, unless I'm missing something, probably am. I don't think AI can make a distinction between comments and statements that are important from the perspective of a board's business and those aren't. I don't think AI can note where an officer or director or guest is actually emphasizing a certain point or saying something that's important to the board's overall consideration. Now, that doesn't mean somebody like me who tends to use his hands a lot and point and do things of that nature, but it does mean something where a scrivener, if a speaker at a board meeting is emphasizing a certain point, the scrivener is able to reflect that. The speaker with emphasis said X. AI can't do that, I don't believe, and that could be important. More broadly, and the AI people can tell us if this is accurate, but my understanding, they're using AI to take minutes creates potential confidentiality and cyber risks relating to whether the AI provider can actually preserve the confidentiality of the meeting conversation and won't intentionally or otherwise use the data to train any other AI model. The risk that whether real people with the AI provider will be able to access the data or share it with third parties. and whether the provider itself has its own cybersecurity program to protect the data. I think those are questions that can be answered. Maybe they can be answered favorably. But I do have these confidentiality concerns and how they also impact boardroom discussions about highly confidential matters like compliance risks and strategies as to litigation and investigations and they're recorded and reported like we just talked about. To me, AI generated minutes are like the use of traditional taping AV equipment to tape full board meetings and create a transcript. Um, they raise the same kind of state consent laws, accuracy issues, confidentiality issues, and especially obstruction related concerns if they're destroyed or deleted subsequently. I'm sure we all know individuals who very conscientiously will use a tape machine to record or a phone to record minutes and then come back and compare their notes to the tape to make sure they're accurate, and that's hard to argue against. The downside comes again whether or not that is that consistent. Does the state allow? Do you have to get the participant or the board members to authorize that taping? And you got to be jumpy about the question of when you destroy or do you destroy the tape and the obstruction of justice issues and how that relates. So a lot of questions, but more than anything else, I think I want a human being involved who can sense the emphasis, the tenor, and the emotion of a meeting and is able to describe that appropriately in minutes. A lot fewer problems with human minute taking, and I think ultimately greater accuracy and reliability. But I'm just one guy.
Nope, I think that's a lot of solid advice there. So let me ask another process question. As a reviewer of minutes, how much latitude do you think we have to modify, change, revise from the initial draft?
This is another, I think general counsel incentive compensation should include a particular incentive goal of how quickly and completely he or she can review board minutes. My view, first of all, is get the review done as close as possible. You want the minute taking, the first preparation of the first draft to be as correct as possible. In other words, do your best job on the first cut of minutes. Be consistent in your approach to minute taking and put a fair amount of effort into getting the first draft right. Number two, I think more to your point, let's please limit the number of people who have their hands on the draft minutes before finalizing it. I get super uncomfortable with allowing very broad input before finalizing it because I think it certainly creates bad optics, or worse, that the subsequent revisions aren't made in good faith. They're made by people who have a desire to push a particular perspective, or they want to delete things that to them might be embarrassing but are relevant to the overall reporting. So I recommend, again, sorry, but that's why I want your incentive comp to reflect this, that the general counsel review the review process, monitor the review process, set guidelines, just to really reduce the potential for revisionist history or the optics of revisionist history. And when you've got 5, 6, or 7 people with their hands on the minutes, I think it's going to take longer, and then it's going to diminish the credibility of those minutes.
So Michael, we've talked about a lot today, a lot of legal principles, a lot of theories, but one of the benefits for our membership, for your expertise, is a lot of practical pointers. So as we come down the home stretch of this podcast, what practical pointers would you want to make sure to share with our listeners related to minute taking?
Yeah, I have some thoughts, Robin. They've kind of stuck with me for a long time, and they're pretty basic. If it didn't happen, or someone didn't say it or do it, it can't be documented and it can't be included in the minutes. And I'll repeat that. If it didn't happen, or someone didn't say it or do it, it can't be documented and it can't be included in minutes. And actually, there's some case law in Delaware where general counsel got in substantial trouble for altering minutes to reflect comments that really didn't occur in the meeting. Number two, if you haven't reflected in the documentation, then from the law's perspective, it's almost as if it didn't happen or someone didn't say it or do it. This goes back to the Chief Justice's comment about the credibility of minutes and wanting to make sure that there's consistency between people's recollection of the minute and the minutes themselves. If it's not reflected in the minutes, then someone's going to take someone who doesn't have the company's best interest in mind is going to say it didn't happen. And then you have to go through the whole process of a witness testimony or depositions or such that said it does, but you don't have the minutes to back up the testimony. That's number two. Number three, very important, minutes are not the antidote to deficient fiduciary conduct. If you screwed up in the way you exercise your fiduciary duties in a board meeting, the way you prepare the minutes aren't going to make that prettier. It's going to come out whether if you did something or you didn't do something that's consistent with your duties. You can't prepare minutes to overcome that, or you can't. And if you have a short form minute, it's going to get out. So minutes are not an antidote to deficient fiduciary conduct. But the last one, Rob, is minutes are valuable. They can provide substantial defensive and I think offensive value to the company if they're done well. And I think ultimately, if you get into the practice of doing this in a certain right, prompt way, it's just an enormous protection for the organization.
So, Michael, thanks as always for sharing your thoughts with us. I've taken extensive meeting minutes of our conversation today. I appreciate
not on AI, I hope. Yeah.
Not with AI, but without the Bears to watch this weekend. Can you give me a timely review of those minutes?
Yeah, that's absolutely. Be right back to you.
So we'll be back again next month with our next podcast and our continuing series where we'll focus on 3 important governance developments. 2 are new Delaware decisions related to impacting the application of the Caremark standard. We'll also look for the response of the Audit and Compliance Committee to the latest policy positions of the Department of Justice as it relates to fraud enforcement. So, Michael, thanks for the robust conversation today. And
thank you, Rob.